Hello YouTube, I'm Vince White. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. And as you can see, I have been called to New York. I am not on my hobby farm, which specializes in losing money. Just a hand over fist, turning dollars into root vegetables. I'm not there. I've been called to New York for work, and so I must be here to do the work for the clients, right? But that doesn't mean the show doesn't go on. The show must go on. We must get folks the answers they need from an employment attorney. So like, subscribe, comment down below. It helps me to help more people just like you. We have a rather depressing question from YouTube user Richard, who asks us, "Hi Vince, thank you for all your informative videos. I just want to ask a question. My right to sue letter expires on September 23rd. Now, quick background information. The EEOC, which is what I assume Richard is speaking about here, will issue at the close of their investigation generally what's called a right to sue letter. That right to sue letter is the key to filing in federal court, and it gives you exactly a 90-day window from the date you receive it to get filed in federal court. Just be aware of that. We have videos in the channel about documenting how when you received your right to sue letter and all these things. So be aware. Richard goes on, I have contacted over 40 law firms and no one is willing to help me. My time is almost up and I do not know what else to do. Do you have any suggestions? Okay, so I'm going to give you a couple of annoying suggestions because they're going to direct you to other videos, and that's kind of annoying. I'm aware of that. I'm also going to give you kind of a last-ditch suggestion here to buy you more time, okay? We have a playlist on the channel about how to find employment attorneys. Seems like you found a lot of them. You found 40. It sounds like you've had conversations with 40 of them. It hasn't gone well. I don't know how much that playlist is going to help you. But there's videos in that playlist about packaging your case up to make it more appealing to employment attorneys. And those videos might help you to obtain the representation you need to get your case moving. Now, if you want, and I think your YouTube username here might be your real name, and it's not good. It's a hard no for me. I'm not going to be pushing your name out to the world. But if you want to get an anonymous YouTube name, and if you want to present a hypothetical, publicly post it always. Our questions always have to be answered in a public posting because I can't be at risk of disclosing something confidential for somebody or something like that. There's risks to my career that I can't abide. I can't allow. So if you publicly post a hypothetical stripped of all identifying characteristics about your case, I will try to structure your case for you in like an elevator pitch style blurb that I would urge you to give to employment attorneys when you're trying to hire them that would be as appealing as possible. That's what I can offer here. And it might even require a little bit of back and forth. And that's okay. Let's see if we can help, because you're up against it. I mean, you've got, what is today? Today is September the 7th. This video will come out in a couple of days. You're going to be tight up against a window, which is why I'm going to give you this last ditch suggestion. Rather than let your right to sue letter run out, rather than lose those federal claims, I'm assuming your right to sue letter deals with workplace discrimination, workplace sexual harassment, because that's what you would file with the EEOC, generally speaking. You could always file it pro se in the federal court system and then try to hire an attorney after to amend. And many federal courts, you're going to have the right to amend, I should say, you have the ability to amend as of right, meaning you just have the right to do that for a period of time, often in my experience about 120 days. That's a lot of days compared to what you have left right now, which is like less than 20 days, right? So you get something filed and then bring in an attorney to amend it. There's a dark side to this, a downside, and that often attorneys don't want to take over pro se cases in federal court because there's so much work. There's so much work to undoing what a pro se litigant has done. In many cases, pro se litigants will add a lot of risk. They'll get into a lot of additional stuff that creates additional work. So on a case where somebody's been representing themselves pro se, often I'll say that work is tripled or quadrupled, and the risk is often doubled, if not more. So this is not ideal. Ideally, you would start your case in federal court with an attorney with representation of experienced employment counsel, but we're taking swings here to try to help you, right? We're doing what we can in a non-ideal situation, assuming you have a viable claim for workplace discrimination or workplace sexual harassment that went through the EEOC, and now it's hard for you to find representation. So if you want to create that public posting and you want to tell me things like what happened, no identifying characteristics, but what happened, all of it, just like if you want to write me 10 paragraphs, I'll condense it into 5 sentences of like the best pitch ever. And also tell me what these firms are saying to you, right? If these firms are saying, oh, we're conflicted out, we represented that employer, okay, well, that's easy. We just find someone who hasn't, right? If these firms are saying, you scream at us, okay, well, that's also easy. We can work on that and, polish that approach a little bit. And I'm not saying you scream at them. I have no idea. I have no idea why these people aren't helping you, right? I'm trying to be funny and think of what it could be. If there's issues with the case, we'll look at the case and say, okay, so these firms don't think the case is viable. Why not? Is it evidentiary? Do they think they can't prove it? Well, let's look at how we can prove it. Let's look and see if we can help you show them how you can prove it, right? By the same token, if it's an issue with the law, if you're bringing a whistleblower claim, and these law firms don't want whistleblower claims, they want discrimination claims, they don't understand why you took a whistleblower claim to the EEOC, okay, well, let's approach that. Let's deal with it. I can't advise you as the state laws, but I can tell you under the federal laws what they might be looking for, the federal laws that pen through the EEOC, and then you can talk to local attorneys to develop the finer points of whatever jurisdiction you're in, right, for the state law. So that's my suggestion to you. That, Richard, is how I would seek to help you, and it's probably the full breadth and width of what I can offer you today. But I see that date, that September 23rd, and it makes me say, fuck that. I hope Richard's okay. So I am going to also have this video released tomorrow. I'm going to have it bump the queue in the hopes that you don't end up waiting a couple of extra days to get a video from me. For all I know, you've already gotten an attorney, because it looks like this question was posted 3 days ago. And so that's, listen, I hope this video is superfluous. I hope you don't need it. I hope you already have an attorney. You have representation in your cases moving, like going, like whatever hand motion is required for like a case. Run the ball, run the case, right? Yeah, I just saw your question. I wanted to make an answer here. See if I can help. Like, subscribe, comment down below. Helps me to help more people just like you. Take care.